On January 20th, 2024, officers of the Western Washington University Police Department in Bellingham, Washington, responded to a call that an unidentified individual was breaking into a vehicle in the campus parking lot. Sergeant Wolf Lipson and Officer Robert Anderson responded to the call. Through information relayed by dispatch, Officer Anderson learned that it was his personal vehicle that had been broken into. The incident that followed was captured on the officer's body-worn camera.
Hey, let me see your hands. Get on the ground right now. Get on the ground right now. Lay on your belly.
Put your hands behind your back.
X-ray 11 has one in custody.
What you think you were doing on my ride, homie?
Huh?
That's my ride.
Oh, it is?
Yeah.
My bad, bro.
No, it ain't too bad. It's you, dog.
Huh? I got confused with...
You ain't got confused on nothing. You wanted something that didn't belong to you.
No, I thought it was a different truck.
That's a cop's ride.
What?
That's a cop's ride that you touching.
Whoa, man. Take it easy, man.
No, I'm not taking it easy. Shut up.
You, man.
Shut up.
Hey! You...
Shut up.
What? What are you gonna do about it?
That's my ride, man.
What are you gonna do about it? Fuck.
What's your dog's name?
Desna. He just hit me in the face.
Come here.
You guys have camcorders on?
Yep, the recorder's on.
Okay. You wanna hit me again?
Sit.
So I'm gonna file a lawsuit.
You sure can.
Yeah.
Get up.
Nope, I can't get up.
Stand up.
I can't.
Stand up. I got you. Stand up.
Can't.
Stand up.
Bro, I can't.
Stand up.
I have trouble, bro. I'm having trouble breathing. Oh my god.
Stand up. I'm in here to get the truck. I'm in here.
Okay.
There you go.
Don't.
Stand right there. There you go. Turn around. Turn around.
You're squeezing my...
Let me do that.
You punched me in the face, bro. What's your problem?
That's my vehicle.
Yeah, but you're gonna punch me in the face, bro. What's wrong with you? Are you some sort of... Is that what you are?
There you go.
I'm not sitting down until I got a supervisor.
You supervisor right there?
I'm the supervisor.
No, I'm not sitting down until I talk to the supervisor.
Sit down.
No!
There's some supervisor right here. Talk with him.
Okay.
Sit down.
Did you see him punch me in the face?
Yes, I
No,
struck
I
you in the
did
face.
not.
Huh?
Put your feet in, sit down, and
Can
we'll
I
talk.
talk to you?
Sit
talk in a
down
sec.
there.
You follow what he says, and then we'll talk.
He punched me in the face, bro. You see it in my
Yeah,
eye.
I did hit you. That's what I did.
Yeah, you did. That's
Sit down.
not moral.
Sit down.
Put your feet
Put
in
your feet
there,
in.
and sit down.
That's not... You're gonna close the door,
Yes,
though.
sir.
Get seatbelt and then
That's moral. Immoral, bro. Funk.
No.
You're a... Aren't you? Just a... Aren't you? That's what you are, huh?
Turn around.
That's
Turn
what you
around.
are. What?
Turn around. Thank
What?
you very much. Turn around.
What? What?
Turn around.
What? What are you gonna do?
Are you done?
What are you gonna
Are
do?
you done?
You're gonna call me.
Are you
What are
done?
you gonna do? You're just...
Are you done, sir?
You're in... Are you gonna assault me again? You're gonna assault me again?
While placing the citizen under arrest, Officer Anderson informed the citizen that it was his personal vehicle that the citizen was attempting to burglarize, and then proceeded to strike the citizen in the face in what appeared to be an unprovoked attack, as mentioned in many previous episodes. The constitutional framework for evaluating an officer's use of force is governed by a so-called objective reasonableness test, as established by the 1989 Supreme Court case of Graham versus Connor. This framework considers the totality of circumstances surrounding the encounter, along with the severity of the suspected offense, whether the citizen posed an immediate threat, and whether the citizen was actively resisting or attempting to flee. Furthermore, the Ninth Circuit Court of Appeals, which has jurisdiction over Washington, noted that the force required to control suspects is substantially minimized when they are handcuffed on the ground, in the 2003 case of Drummond versus City of. Anaheim, the unidentified citizen was suspected of a minor property crime, remained calm and cooperative before being attacked, and was restrained on the ground and unable to flee when he was struck by Officer Anderson. Considering these circumstances, it is highly unlikely that a court would conclude that Officer Anderson's use of force was justified, and the unnamed citizen would have a strong argument that the strike violated his constitutional rights. After loading the citizen into the patrol vehicle, Officer Anderson appeared to reflect on what had just occurred.
X-ray funds Western. We're code 4 now, 1 in custody.
Dang it!
Well, that hasn't happened here. X-ray, what's going on? Let's, yes, please. This dog belongs to this gentleman here. Yeah, take a minute. I'm going to deal with this guy. Let's see. Dillingham dealt with him before. Do we have ID on him yet?
All this stuff is there on the floor.
Okay.
What's the head?
His head, yeah.
Can you stop doing that, please?
No, because that officer, he hit me in the face.
Okay,
Yes, I did.
we're gonna need to seatbelt you in.
No. No, I'm not letting that cat. Are you?
Enough.
Can't have you slamming your head.
I can't breathe. I can't breathe.
You're yelling.
Help! Help me!
You're yelling.
I can't breathe.
You are yelling.
I
No
can't.
one's pressing
No one's
on your
pressing at
torso.
all.
The
You're
officer
yelling.
punched me in the face.
That's it.
My collarbone. It hurts. I got a lot of health issues. I'm on methadone. I
Okay.
can die.
Do you need medical at all, sir?
I might because of the way you got me to the ground.
Can you roll aid, please?
We'll get medical on you so they can check you out, sir.
You it's on camera. You're not supposed to
Complaining
do
of
that.
a broken collarbone. Male
You're not
in
supposed,
his 20s or 30s, conscious and
you're not
breathing.
supposed to do
We're
that.
gonna have to get another agency to come out here for this one.
You're not supposed to
Yeah.
do that, man.
11, can you also get
Ah,
out here?
You!
So I'm on your legs,
Okay.
and I'm on your butt.
Can you get out belly again?
Okay, I'm not on your torso.
Okay.
And I want you to take a deep breath,
Okay.
and I want you to relax.
Okay, I'm trying to with that guy, the black guy.
Just one of the patrol units
He
to
wasn't
take this case here.
I understand.
excessive force,
I
right?
understand.
And you guys don't believe him. Don't believe me.
What's your dog's name again?
Desna.
Desma?
Desna.
Can't hear you.
Desna!
Desna. Okay, thank you. He has his ID.
Can you get in there?
In his back,
You hit me. It's on your body cam.
Yes, and I admitted to it too. You know, don't steal from my ride, man.
Huh?
That's my vehicle you broke into. I ain't too happy about it.
Throughout the interaction, Officer Anderson admitted multiple times to hitting the unidentified citizen while he was handcuffed, cooperating and posed no threat. Not only would Officer Anderson's conduct likely constitute a violation of the citizen's constitutional protections, but it also likely violated Washington state law. Under Section 9A.16.020 of the Revised Code of Washington, a public officer is authorized to use force only when it is necessarily used in performance of a legal duty. Section 9A.16.010 defines necessary to mean that no reasonably effective alternative appeared to exist, and that the amount of force was reasonable to accomplish the lawful purpose intended. However, if an intentional strike to the face is not necessary, under Section 9A.16, the Washington statutory framework no longer shields officers from being charged with other crimes for their conduct. While Washington law refers to the common law definition of assault, it has developed several statutes regarding assault that would likely apply to Officer Anderson's conduct. For example, Washington's baseline assault statute, Section 9A.36.041, criminalizes any assault that does not meet the definition of statutes covering more egregious forms of assault. If nothing else, this charge would certainly apply if Officer Anderson's actions were deemed unnecessary and unprotected under Section 9A.16.020, considering that Washington's first, second, and third-degree assault statutes are much more specific. It is unlikely they would apply here, but there is an argument that Officer Anderson may have violated the state's so-called official misconduct statute. Under Section 9A.80.010 of the Revised Code of Washington, a public servant is guilty of official misconduct if they intend to deprive another person of a lawful right or privilege, in the Graham case mentioned earlier. The Supreme Court explicitly noted that excessive force used in the course of an arrest invokes the protections of the Fourth Amendment, which guarantees citizens a right to be secure in their persons against unreasonable seizures. If the force Officer Anderson used against a citizen is found to be unnecessary or a violation of the Fourth Amendment, then Washington's official misconduct charge could certainly apply. Once the officer got the citizen under control, Sergeant Lipson attempted to de-escalate the situation.
You were able to do a decent search on him? Or not?
Yeah, I got all the stuff on him. You can search him again.
Okay, I want to make sure he doesn't have any of your stuff.
Yeah, some of the stuff he has on was
I don't. Stop hurting me, though.
Oh, I'm not hurting you. I'm just checking your
He's not hurting you. You know he's not.
Okay?
Yeah.
Yep. Get your left foot.
Ow! Don't pull me like that!
I was setting you up, shake a few.
My handcuffs hurt.
I was holding your arm, not by your handcuffs.
The handcuffs are too tight or what? You need them loosened?
Yes, they're tiny.
Lean forward. I'm trying to loosen these cuffs for you. We got medics here to check on you.
No.
You said you were in pain. You were feeling a certain kind of way, weren't you?
Yeah, I guess, but...
Well, we're not medical professionals, so we have someone who is.
Can I take my dog with me with them?
What's that?
They usually let me.
Well, let's see what they have for you at this point.
Okay.
I'm going to read you Miranda rights, okay?
What am I being charged for?
Well, we'll let you know, okay? What right now is basically if we have vehicle prowl. That's basically entering vehicles without it.
Second degree?
So you have the right to remain silent.
Okay.
Anything you say can be used against you in the court of law.
Okay.
You have the right at the time to talk to a lawyer if they have been present with you while you're being questioned.
Okay.
If you cannot afford to hire a lawyer, one will be appointed to represent you before questioning if you wish. You hear me, Julio? Do you hear me?
Yeah.
If you cannot afford to hire a lawyer, one will be appointed to represent you before questioning if you wish.
I understand.
You can decide any time to exercise these rights and not answer any questions, make any statements. You understand these rights?
I understand the rights.
All right. Having these rights in mind, do you wish to talk to me or us
About what?
about what happened here today?
I was on scene and I was looking through the window and for some reason, I was in a dream, so I didn't realize I was opening the car thing and going through it.
Well, you broke into the window. It looks like this. So what did you use?
I don't even remember. Is there a tool?
Yeah, there's a stick over there. Why don't you talk to the firefighters for a little bit?
The officers informed the citizen that he was being charged with so-called vehicle prowl. The citizen voluntarily waived his Miranda rights and spoke with the officers about the alleged crime. Regarding the criminal charge, the officers were likely referring to RCW 9A.52.100, which criminalizes entering or remaining unlawfully in a vehicle other than a motorhome. Considering that when the officers arrived, they caught the citizen inside the vehicle and captured this on body-worn camera, it would be difficult for the citizen to defend himself against this charge. However, the citizen's later decision to waive his Miranda rights and speak to the officers was equally detrimental. In the 1966 Supreme Court case Miranda v. Arizona, the court held that when police take a citizen into custody and interrogate them, the Fifth Amendment privilege against self-incrimination is at risk because the setting is inherently coercive. To preserve this right, the court established a requirement that law enforcement provide specific warnings before interrogating a suspect, now known as a Miranda warning. Even in instances such as this one, where officers already possess strong evidence from personal observation, a citizen's statements can still supply direct proof of intent, motive, or a separate crime entirely. Voluntarily waiving Miranda rights is almost never the most legally prudent way to navigate a police interaction. Here, the citizen voluntarily engaged in dialogue with the officers after being read his rights, meaning all of his statements could be used against him in court, including any indirect admissions of committing suspected violations.
Julio, you have a broken collarbone? Is that what's going on?
I have all types of problems, so I can't really move. Missing, they got stolen. I have no many. It seemed like just walk out and get as many more as I can.
What went missing?
My and then my messenger goes.
Yeah.
Okay. Well, it seems like both your collarbones are intact. So that's excellent news.
So far, all I know is his first name is.
What would you like from us?
today? Probably that. Yeah.
If we can't ID him, I can see if the jail will take him and just do a roll prints and photo and ID him.
Last time I tried that, they wouldn't do it. Bellingham has their APHIS hooked up machine thing. They want to know, I mean, if we're not, they need one of us to be in the ambulance with him if he's going to stay handcuffed and in custody.
Yeah.
We'll take the cuffs off then?
Well, it's up to you guys if he's going to stay in custody or not, because if he goes to the hospital in custody, then it's...
Yeah, one of us has to go with him.
Right. Can you turn your camera off real quick?
Yeah.
Sergeant Lipson ordered Officer Anderson to shut off his body camera, and the citizen was transported to the Peace Health St. Joseph Medical Center for treatment. Following the encounter, Western Washington University Officer Terrence Cunningham, who was not involved in the incident, saw the body camera footage, noted Sergeant Lipson's inaction, and decided to report the incident directly to Police Chief Katie Pottatz. Upon being notified, Chief Pottatz contacted the Bellingham Police Department to conduct an impartial internal review of Officer Anderson's conduct. The chief also contacted the Mount Vernon Police Department to request a criminal investigation be launched into Officer Anderson. Both Officer Anderson and Sergeant Lipson were placed on paid administrative leave pending the results of the investigations. The Bellingham Police Internal Review concluded that Officer Anderson violated state law and 4 department policies, and that Sergeant Lipson violated 7 department policies. The criminal investigation launched by the Mount Vernon Police Department was eventually forwarded to the Whatcom County Prosecutor's Office, which charged Officer Anderson with 4th-degree assault. Following the investigations, Officer Anderson was terminated and Sergeant Lipson retired before the internal investigation could be officially completed. Former Officer Anderson pleaded guilty to 4th-degree assault and was sentenced to 24 months of probation, a $350 fine, a 364-day suspended sentence, and was required to attend anger management classes. Less than 3 months after being fired from Western Washington University Police Department, Officer Anderson was rehired by the Lummi Nation Police Department, where he had previously worked for approximately 3 years before quickly being terminated again less than 3 months later. The Washington Criminal Justice Training Center, responsible for certifying Washington law enforcement officers, announced that it would conduct an investigation into former Officer Anderson's certification, which remains ongoing. It is unclear whether the unidentified individual filed any formal complaints or intends to pursue legal action. Overall, Officer Anderson and Sergeant Lipson are at fault. Officer Anderson for blatantly assaulting the citizen while detained and cooperative, Sergeant Lipson for failing to intervene or meaningfully de-escalate the situation, and both officers for demonstrating a glaring lack of professionalism and accountability. As mentioned before, the governing standard for force during an arrest is the objective reasonableness framework from Graham. Under this framework, an intentional strike to the face of a citizen who is already restrained, cooperative, and under control is not plausibly justified by any legitimate law enforcement need. The suspected offense was a property crime, and the citizen's ability to threaten officers' safety or escape had been substantially reduced once he was on the ground in handcuffs. Furthermore, Washington's statutory framework authorizes officers to use force only when it is necessarily used in performance of a legal duty, which requires that no reasonably effective alternative exists and the amount of force is reasonable to accomplish the lawful purpose. A handcuffed citizen on the ground who is not actively resisting presents obvious alternatives, including continued control, separation, and transport. Once force cannot be characterized as necessary, the conduct is no longer insulated by statute and can be evaluated under ordinary criminal laws. Officer Anderson's conduct was unacceptable, and the fact that he remains technically certified is troubling. While Sergeant Lipson may not have physically attacked a citizen, as the supervisor on the scene, he was responsible for controlling the encounter, preventing further unnecessary force, and restoring professional distance when an officer becomes personally entangled in an event. He failed to do all of this. Officer Anderson's personal connection to the vehicle created an obvious risk that the arrest would become personal, and Sergeant Lipson's failure to separate him from the citizen reflects a breakdown in supervisory judgment. Officers are allowed to be angry about a suspected burglary, but they are not authorized to use anger as justification for force. Supervisors cannot treat an officer's loss of control as a tolerable byproduct of the call. This interaction highlights how quickly legitimacy collapses when personal emotion enters a custodial arrest. The unidentified citizen also bears responsibility for attempting to burglarize a vehicle, voluntarily waiving Miranda rights, failing to maintain composure, and using highly offensive slurs. While it is not proven in court, the citizen was likely guilty of vehicle prowling. Whatever misconduct occurred on the officer's side does not retroactively legalize breaking into a vehicle or erase the citizen's legal exposure. When a suspect is encountered inside a vehicle during a lawful response and captured on body-worn camera, factual disputes that generally drive defense are largely absent, leaving little room to contest whether the elements occurred as alleged. The citizen's post-arrest decision-making greatly exacerbated his legal exposure. Miranda warnings exist because custodial questioning creates a heightened risk of self-incrimination, and once voluntarily waived, statements become usable evidence. Voluntary statements can supply intent, motive, and narrative detail that the prosecution might not otherwise prove. Here, the citizen engaged with the officers after being advised of his rights, making statements that function as admissions rather than preserving defensible silence. His loss of composure and use of slurs was self-destructive and unproductive. Escalating into a verbal tirade does not strengthen his legal position and risks shifting attention away from the officer's misconduct. This interaction highlights how quickly a citizen can exacerbate a bad situation by compounding clear criminal exposure with avoidable self-incrimination and inflammatory conduct, undermining credibility later in court.